for the management of recovered assets. We all are aware that Nigeria, every day, government officials in Nigeria are either looking for vehicles to buy, looking for offices to rent. In fact, there are a lot of government ministries that are renting offices. And then it's a shame that we have assets that we recover that are wasting away while people are going around expending public funds on recordings that could be avoided. So this public hearing is one of the ways we're looking for ways to actually identify gaps in the recovered assets management process. So identify ways of actually looking at converting proceeds of crime into assets for the government of Nigeria. So we're here to work together and believe that with the public hearing, we can all put in place the proper legislative and administrative procedure to strengthen our fight against corruption. So thank you. What we will do first is do an introduction of members of the committee. Then we'll, move to your side of the table.
My name is N2bn, Malami, the Attorney General of the Executive Minister of Justice. And with me, the Chairman and the honorable members, the Permanent Secretary and the State General of the Minister of Justice, in the person of Learned Senior Advocate Dayo Apata. And we are in this meeting supported by some technical staff of the Asset Recovery and Management Unit, inclusive of Ajia Ladidi Bara'atu Mohammed and Bunmi Naijo with us for the purpose of these proceedings, and we thank you most sincerely for according us an opportunity to be physically and personally present. We thank you most sincerely for the honor. Thank you.
Take us through the status of recovered assets and the cost management of state forfeited assets. How is it done?
Well, I think there are multiple dimensions to it. It all depends on which of the dimensions you want me to address, and I'm ready to address the multiple dimensions. Some of the dimensions that are associated with it are the international recoveries. Another dimension is the local recovery aspect of it. The other dimension equally is the legislative aspect of it. Where are we as far as the support for the recovery and disposal of assets are? And indeed the executive dimension. What have we done in terms of recovery, disposal, and tracing of assets? So it all depends on which of the areas perhaps the committee is interested in me, and I am equally ready to take them one after the other if it is the desire of the committee that I should do justice to all of the enumerated, multiple dimensions enumerated.
The mandate of the committee. You're looking at not just from 2015, today we're looking at recoveries even down to Abacha era. How much has been recovered cash? How much has been appropriated? How much has been utilized? Do we still have anything left? Are we still making recoveries? And then what happens to all the immovable assets? What's happened to them? I think we can start from there.
To my tenure in office 2015 to date, with particular regard to the recovered assets, taking into consideration that the 2002, which is an area indeed being considered by the committee, and up to the point of 2015, I was not in office, and I may not be in a sound position to give a comprehensive rundown as to that area. But one thing that I think is important before coming down to figures is the fact that at the time we came into office, we realized that there was no coordinated, organized way and manner through which recovered assets were being coordinated in terms of disposal and associated things. So what we did was indeed to put in place a legal framework, to consider the possibility of having a legal framework, and developed a proceeds of crime bill, which was transmitted by the executive to the National Assembly as far back as 2017. Embedded in the process of crime bill was the asset management and recovery agency. And I regret to state that as far back as 2017 to 2019, up to the present moment, that legislative framework could not be achieved on account of the fact that the asset recovery proceeds of crime bill was not passed by the National Assembly. As I'm talking to you, it has been a work in progress. So my take on it is, if indeed the National Assembly had passed the proceeds of crime bill, we cannot be here scampering and indeed perhaps scouting for information relating to the recovered assets, because that bill has indeed put in place an effective mechanism, both in terms of database, in terms of disposal, processes, and procedure. So the starting point is to state that there has been inaction on the part of the National Assembly with particular regards to having in place a coordinated legal framework on assets, tracing, disposal, and management. Now, coming to the recovered assets. Let me state that at the national level, in terms of recovery, notwithstanding the absence of the Proceeds of Crime Act, or perhaps the passage of the Proceeds of Crime Bill, we have tried to record some modest achievements in terms of our international engagement as far as recoveries are concerned. In that respect, we have succeeded in December 2017 to recover 322 million US dollars from Swiss. That asset recovered is known as Abacha 2. Again, in 2020, precisely in May 2020, we have succeeded in recovering 311,797,866.11 cents from Island of Jersey, United States of America, and indeed UK. And we have equally, in October 2020, recovered 5,494,743.71 euro from Republic of Northern Ireland in Nigeria, known as Abacha 4. And of recent, we have succeeded in May 2021 in recovering the sum of 4,214,017.00 pounds from UK, known as Ibori loot. And all these assets, as recovered, are indeed lodged with the central bank account on asset recovery, and the receipts of the amount has been confirmed by the central bank. But let me state that recovered asset has indeed constituted an item, budgetary item, that has been appropriated by the National Assembly, and among the monies or perhaps assets expected to fund the national budget of the federal government has, as a matter of policy, been made part of the budgetary arrangement of the federal government, and it was indeed among the expected items appropriated by through the appropriation by the National Assembly. So the implication of what I'm laboring to state is that these recovered assets and much more that were being recovered locally constituted a budget line item. And these monies, upon recovery and lodgement with the central bank account on asset recovery, are eventually transmitted to consolidated revenue fund for utilization by the federal government in servicing the budget demands of the federal government. Of course, let me state further that on account of the fact that Nigeria as a sovereign nation is not exclusively involved where international recoveries are concerned, it calls for mutual negotiations and determination. For example, when we are negotiating the 322 million US dollars originally recovered in December 2017, arising from the fact that we were governed not exclusively by the Nigerian law, but by international convention relating to international recovery, taking into consideration that Switzerland, as a sovereign nation, was involved, and negotiations were necessary. We had to sit down, discuss, agree, and negotiate with Swiss, governed by international conventions, our local laws, their local laws, among others, to agree on an arrangement that has to do with the disposal, or perhaps with the disposal of the assets in contention. And we agreed on social investment programs, among others. Now, which social investment programs are we talking about? The N-Power program, Trader Money program, and associated school feeding program, and associated incidental programs of the federal government relating to support for the less privileged and indeed the indigent and disabled. It was commonly agreed among these nations that these monies should be extended in that respect, and the money was indeed accordingly applied. Now, coming to the second tranche, which was 311 million US dollars recovered from island of Jersey, United States of America, and UK, we equally negotiated on the projects in respect of which these monies were to be applied, and arising from the international negotiations among sovereign nations guided by the international conventions relating to the asset recoveries. It was agreed that these funds be applied on 3 major Nigerian projects, that is Abuja-Kano Expressway, which I am happy to state that is progressing modestly in terms of infrastructural development, Lagos-Ibadan Expressway, which is as well been aggressively pursued, and indeed Second Niger Bridge. All these were budgetary items, and there was budgetary provision for them. And then indeed, the budget item relating to this project was there in the budget and appropriated by the National Assembly. So these funds were agreed to be applied exclusively for this project, and I'm happy to report that this is what is being transparently and accountably done by the federal government in terms of application. Again, we have equally recovered from Republic of Northern Ireland the sum of €5 million on 2nd October 2020, which amount was equally remitted to the Consolidated Revenue Fund. So by and large, as far as the government of President Muhammadu Buhari is concerned, recovered assets are substantially products of international agreement, international agreement and understanding, and on the basis of that understanding as agreed, the recovered assets are factored as a budgetary item in our national budget, passed by the National Assembly. So what I'm saying in essence is indeed a tripartite cycle of the executive, the legislature, and international negotiations as far as the internationally recovered assets are concerned. So the executive factor the recoveries, as a budgetary item in the budget. The legislature passed it on as a budgetary item, approved it, and indeed the executive deployed same as agreed in the budget, and the international community is carried along in terms of the project that needs to be, for which the funds need to be applied, and we have been wholeheartedly operating within that cycle as far as for the purpose of sustenance of transparency and accountability. Now, coming to the local recoveries, for example, there has been local recoveries of looted assets. And, but then, as you rightly know, Nigeria as a nation has a lot of institutions that have been in existence arising from the existing legislations, inclusive of, for example, the Federal Ministry of Justice, EFCC, ICPC, NDLEA, Customs, and a host of other agencies that are established by law. And part of the functions of these agencies are recoveries, among others. So over time, there has not been a coordinated and organized way of recovery, tracing, recovery, and disposal of these assets. So when we came in as a government, President Muhammadu Buhari came up with a policy of ensuring transparency of these processes. And arising from that, the President directed the opening of official accounts, among which are CBN, Office of the Accountant General of the Federation, Federal Government of Nigeria Asset Recovery USD account, whereby all recoveries in US dollars are lodged. CBN, Office of the Accountant General of the Federation, Federal Government of Nigeria Asset Recovery GBP, that is a pounds account, was established. Asset Recovery Euro account was established. Asset Recovery Naira account was established out of desire to have some level of transparency and accountability as to what we do in terms of recovery. And these accounts, the details of which were made available to you, were indeed in place by the federal government, inclusive of interim forfeiture and final forfeiture accounts. So whenever there exists an interim order of forfeited assets by the judiciary through judicial process, the amount recovered through the interim forfeiture are lodged into the interim forfeiture account. Amounts recovered as a result of final forfeiture are lodged into the final forfeiture account. And the recovery accounts in dollar, euro, pound sterling, among others, were established, and these monies are lodged there for the purpose of transparency. So when eventually you have a final forfeiture or perhaps final lodgement of assets that are legitimately due to the federal government, the Ministry of Finance direct transmission of such assets into the consolidated revenue account for the purpose of expenditure of the federal government. So what I'm trying to say in essence, that there exist specified and dedicated accounts relating to each and every currency component by the federal government, and those accounts host the recoveries made by the federal government. Final forfeiture amount goes to the final forfeiture account, and then from there, the Federal Ministry of Finance direct the transmission of them into the consolidated revenue account. Interim forfeiture are lodged into the interim forfeiture account with the central bank, pending the final determination of the judicial process relating to the forfeiture. When eventually the case is determined, and then the court directs the final forfeiture, it goes to consolidated revenue. If it eventually directs that the amount should be paid back to the subject of investigation, it is paid back to the owner. So in essence, we have significantly under the leadership of President Muhammadu Buhari, tried to bring about the desired transparency and accountability of the recovered assets, and relevant accounts are indeed established. So, but then, for the purpose of ensuring now the disposal of the assets, the tracing, recovery, and disposal of the assets, I have told you earlier that the relevant bill that could have brought about the desired transparency, the desired consistency, organization, and coordination of the assets is still pending before the National Assembly and has not been paid. But then, out of desire to ensure the desired accountability on the part of the executive, we have what is, established in the Office of the Attorney General, Asset Recovery and Management Unit, sanctioned by the head of service and established on that account. And a database has indeed been established that captures the desired information relating thereto. But one thing that I think is of interest as far as the management of asset, or perhaps the Asset Recovery and Management Unit in the Office of the Attorney General is concerned, is the fact that arising from the powers of the Attorney General within the context of the law, with particular regard to Section 150 and indeed Section 174 of the Constitution, and indeed enabling laws inclusive of the EFCC. Yes, and indeed enabling law inclusive of the EFCC Act, among others. The Attorney General is empowered to put in place some level of transparency associated with asset management and disposal. And then, arising therefrom, we put in place regulation. The desire and the intention of the regulation is to have some level of visibility, guidance, consistency, and transparency in the process. And we have, as a result, put in place asset recovery regulation guidelines. We have, arising therefrom, put in place asset tracing, recovery, and management regulations of 2019. The intention is not to allow the process to be unguided. And the asset tracing, recovery, and management regulation 2019 put in place comprehensive standard operating procedure. And I think one point of interest relating to the Asset Tracing, Recovery, and Management Regulation 2019 is that all the agencies of government that are in one way or the other involved in the tracing, recovery, and disposal of the assets are members of that committee. So we have, as members of the committee, the Office of the Attorney General, the EFCC, the ICPC, NDLEA, Navy, which is the custodian of the vessels that are being perhaps detained on account of one infraction or the other, DPR, that are responsible perhaps for providing the security of the assets on board vessels, if any is found, civil defense, NDLEA, and a host of others, inclusive of the police. And then that committee is put in place and inaugurated by the Attorney General, and they are now working together, guided by the guidelines for the purpose of ensuring transparent disposal of the assets. And that committee is chaired by the Solicitor General of the Federation, and all these agencies of government are indeed inclusive of the Ministry of Works and Housing. The Ministry of Works and Housing, for example, is a member taking into consideration that the assets are by tradition and convention to be valued by a department in the Federal Ministry of Works. So whichever asset is indeed meant for disposal must naturally be valued by the Federal Ministry of Works and Housing. DPR, for example, is a member because they are responsible for measuring the quantity and indeed weight of a product, if indeed any product is found on board a vessel, and they are members that will be responsible for assessing the content of a vessel in terms of perhaps a petroleum product, if any. Navy is a member because they are the custodian of some of these vessels. EFCC is a member because they are in charge of economic crimes, and indeed, perhaps when the need for further prosecution or associated things relating thereto arises, they are already on the ground. The Office of the Auditor General is equally a member of that committee, and the intention is to ensure that necessary audit processes are indeed complied with. So, and the same thing as public procurement. So this indeed is what we have put in place as a matter of necessity on account of inability of the National Assembly to provide the legislative framework necessary and required for consistency and efficiency of the system. Perhaps maybe by way of a general rundown and giving a modest insight as to the processes and associated things, that is what we have done, and I'm ready to take further questions. Thank you.
Thank you, Mr. Attorney General. Note why you were speaking, and I think I'm going to start from exactly where you stopped.
Yes, sir.
Making laws.
Yes.
Goes through processes. You're aware of that?
Very well.
So which means, the fact that you sent an executive bill doesn't mean that that's the day it's going to be passed.
Yes.
Okay, so I believe that's in progress. But in the absence of this Proceeds of Crimes bill, act,
Yes.
are there any existing laws for management of proceeds of recoveries?
Well, there are indeed, but one thing that I think I need to make clear is that these laws have not been very helpful in terms of coordination and efficient management of the resources, because there are laws that are scattered. For example, talking of the EFCC Act, sorry? Yes. For example, talking of EFCC Act, for example, Section 31 and Section 43 of the Economic and Financial Crimes Commission Establishment Act 2004 provides, and I read, the Attorney General of the Federation may make rules and regulations for the disposal or sale of any property or assets forfeited pursuant to this Act. So it was on account of this, among others, taking into consideration associated powers of the Attorney General as contained in Section 150 and Section 174 of the Constitution, that the Attorney General, being perhaps having considered the fact that the legislative processes, which takes a longer period of time, which could have addressed the problem of consistency and efficiency in management of assets, came off with the Asset Tracing, Recovery and Management Regulation 2019, so that the assets that has been there unattended over time on account of absence of the legislative framework came up with the regulation, and it was on account of that the committee was put in place to see what can be done in terms of salvaging the assets that has been dispatching over time, that have been depreciated on account of the absence of a coordinated legislative framework.
Thank you. You did mention EFCC Act empowers you to take certain action in the Navy, do you?
We do not have similar act as it relates and statutory responsibilities. There are incidental expectations on the part of the Navy with particular regard perhaps to the provision of security of the assets, disposed assets, for example. If you are talking of vessels, for example, you understand there is no institution of government that is saddled with the responsibility of taking or perhaps providing the desired security and maintenance of same other than the Navy. That answers your question, Mr. Chairman.
Go ahead.
I'm in agreement with you that yes, there is a legal lacuna which ordinarily should have been addressed.
Yes.
By the bill, which I believe is an executive bill, which is with the Parliament.
Yes.
But that notwithstanding, our existing laws actually make provision for management and administration of these proceeds.
Yes.
Because in my opinion, they amount to revenue.
They are not.
I mean, eventually they transform to revenue. And that is why I was a bit worried yesterday when I didn't see my brother, the Accountant General of the Federation,
Yes.
to take, any proceeds anywhere that has been recovered. I'm also in agreement with you, sir, that these proceeds have been captured in the MTF, which pursuant to provisions of Fiscal Responsibility Act, is which expects Mr. President to lay before the Parliament for approval before the budget is transmitted. So I am in agreement with you with everything you said. Mr. Chairman, I just want to draw attention to what we should actually focus on. What we should focus on is the Attorney General and his team. I will recover this loot. Our focus should be application. Application, so that we don't waste time. We should actually focus on application. The Accountant General being the Chief Treasurer, the Chief Accountant of the Federation.
We're going to do that. I think what we're trying to do was, because the rates that we do understand international assembly, we needed to let him know that it's not like, I think it was, it was an indirect thing that not related to that, we due to that. Mr. Attorney General, I think there was one other thing you said. You said every fund recovered either as cash or from sale of assets is transferred into the consolidated revenue account. Would that be correct?
No, it's not right, sir. You see, funds generated generally, they equally have multiple dimensions. For example, there are certain recovery processes initiated that are through judicial process. While the case is ongoing, you may make recoveries before the final determination of the case. As far as those funds as far as the recovery of those funds are concerned through the investigative processes, while the case is ongoing, they are not funds available for immediate transmission to the Consolidated Revenue Fund, because their availability for transmission to Consolidated Revenue Fund is contingent on judicial determination of the case. So you have in place, available at the central bank, what is called interim forfeiture account.
No, we're aware of that, but we're not going to dwell much on interim forfeiture account.
Okay.
We're asking for final forfeiture account.
So when the funds are finally forfeited, the Federal Ministry of Finance has the responsibility of taking custody exclusively, and the Office of the Attorney General has no role whatsoever to play as far as the administration of those funds are concerned.
Okay, let me put it this way.
Yes.
The assumption is that whatever is in a final forfeiture account, every revenue will be transferred into the consolidated revenue account.
That is assumption.
Good. Now, can spendings be made before the funds are transferred to the revenue account, to the consolidated account?
Not by the Office of the Attorney General. Is never a signatory to any of such accounts. Not a signatory to any of these accounts, the interim, the final, and associated, and on much less of the...
Has the Office of Accountant ever received funds from this account?
Sorry?
Has the Office of Attorney General ever received funds directly from this account?
The Office of the Attorney General has at no point in time ever received a kobo associated with the recoveries, because not even cost of collection has been sanctioned by the federal government. So the Office of the Attorney General is not a recipient, is not a beneficiary of a dime arising from this account.
I'm going to send a statement of account from CBN from the account.
Yes.
Showing payment to your office on 20th February 2017.
Sorry. Which particular item? The one highlighted? I have seen multi-debit entry, but I don't know what that stands for.
Who is the recipient?
Sorry?
Who is it paid to?
MDC paid beneficiary. Which one? What is this?
Please, somebody can read it out. I think you should read it out. What's the beneficiary, the name of the beneficiary there?
Perhaps, Chairman, maybe kindly read it. I can't read it here. I've not seen.
They told us a non-truth.
We'll address it, Mr. Chairman. Let us just share, look at it.
Attorney General is did money from the recovery account. Mr. Chairman tendered a document before the Attorney General, which we don't have the document. Can you kindly, Mr. Chairman, read to us what is contained on the document so that we can move forward?
Mr. Attorney General, I think
The Attorney General of the Federation and Minister of Justice had a budgetary provision in the 2016 budget of about 3 billion to fund certain critical activities, especially the backlog of solicitors' fees, as well as properly repositioning the ministry. So what I'm trying to say arising from this paragraph is budgetary provision and not recovered assets.
I can hear you clearly. I
So-
can ask you a question.
Yes, please.
Do you pay money for budgetary position from recovered account or from the consolidated revenue?
So where the money comes from is a function of the Federal Ministry of Finance, and I'm not making specific requests out of the recovered assets, not at all.
The question I asked you was, have you ever received monies from the recovery account? And you said no.
Not the recovery, budgeted money, as budgeted and appropriated by the National Assembly, but certainly not exclusively from the recovered assets. From the recovered assets, no. Budgetary provision, yes.
It's a good thing the Accountant General is here, so we'll take it to him later.
Yes,
but
please.
then I still want you to look at this.
Yes.
What does the payment, what payment from a revenue account, do you pay to ministry from a revenue account or from the consolidated revenue account?
I am not in a position with the Federal Ministry of Finance to Federal Ministry of Justice were made from. That is exclusively the mandate and function of the Federal Ministry of Finance and not the Office of the Attorney General. Once there exists a budgetary line, budgetary item, my responsibility is to make a request to the Federal Ministry of Justice, and I do not deduct at source.
No, the reason we're taking you on this, because you're the chief.
Really, no recovered items.
Okay, as a law officer,
Yes.
are you saying that the Federal Ministry of Finance has done something illegal?
I am not in a position to assess them. All the facts are not before. My responsibility is to consider fair hearing, and I have not heard from
There's
them.
a possibility that they have done, and they have done something that they should ordinarily not do.
I cannot be preemptive in assessment when the facts are not fully before me.
Thank you.
Like I've said before, the Attorney General has clearly laid the legal framework, the background, and he has, as far as I'm concerned, he has shifted the issues of accountability to the Ministry of Finance and the Accountant General of the Federation. Sir, the Attorney General has also cleverly shifted the issues to us that the money he asked for is based on their own act that we produce, the Appropriation Act. That being the case, Mr. Chairman, the area we should focus our attention to is to tell Nigerians, is to account to Nigerians their assets, their funds that were entitled, stolen, looted, that has now been recovered or that is undergoing recovery, and which are now in the hands of the Accountant General of the Federation. which we also as a parliament also recognized in our projection in the MTEF, in the Appropriation Act, made provision to. Mr. Chairman, sir, now the issue we should shift attention to are two in nature. One, Mr. Chairman, take note, the assets recovered, were they sold at a rate that is undervalued? Two, the money so recovered, what they were put to be used on, is there value for money? If there are projects, can we conduct, aside financial audit, can we look at performance and project audit? I think that is the focus of this committee. And we're also backed by the Constitution that we should harness our resources and then ensure that they are efficiently deployed. So, Mr. Chairman, sir, we should look at the funds, the application, what the funds that have been recovered, what they were applied to. And we should shift the issues to the Accountant General of the Federation.
Honorable.
Thank you.
Honorable, I think inventory. When you're inventorizing, it means that you look at everything. What's been forfeited? What's still being held? Then the management. Management is not just when it's explained, it's even the process. If you're supposed to manage something and you're not following due process, you have failed to manage. If the law says that every revenue should be paid in the consolidated revenue account, and you start spending money from the recovery account, there is an infraction. Good. So that now, because our job is to investigate and look at process as well. And that's why we're asking this question about process. Is it possible? I mean, I'm Yoruba. In my place, they said, only God judges a man who shares teeth with his mouth. What we're asking is this looted fund being shared like a man who's sharing meat with his teeth? We need to assume that the meat is on the table and is being shared openly, rather than being shared with the teeth. I think that's what we're trying to cover there. Thank you.
From head to toe. I think, Chairman, since we had the Attorney General of the Federation, and he read the laws, and he even read relevant laws passed by this National Assembly in terms of the MTEF, in terms of the Appropriation Act, and in terms of even the EFCC Act. Like my honorable colleague said, okay, let's listen to him. Along the line, when we listen to other stakeholders, like the Accountant General of the Federation, and any other agency that is holding the recovered loots, whether it's transferred to consolidated revenue account, whether it's holding somewhere, whether it's generating interest somewhere, then that will give us another mandate to go further and found out, so that when we are doing our mandate, one, like you said, the management, two, the sources, how the recovered loots, even if it is in terms of property or in terms of cash, even now, their application, how, the relevant laws, how, so that this is, we go step by step, so that at the end of the day, we come up with something that we tell Nigerians, this is the position of their recovered loots. Thank you, Mr. Chairman.
Thank you, Honorable. Office and other arms of government shall maintain a separate bank account for revenue at the Central Bank of Nigeria or any other designated bank by the Accountant General. The balance of the account shall be transferred to the Consolidated Revenue Fund account as in Financial Regulation 209.
Yes.
On no account, I want to repeat that, on no account shall any withdrawal be made from the revenue account other than for the purpose of transfer to the consolidated account.
Yes.
Now, if money is being paid from the recovery account to parastatal, I mean, I'm not saying there's a problem there, Attorney General. It's an question that we're going to put to the Accountant General of the Federation when it comes to him, but we're just paying attention to that. So it's not about saying we're looking at recovery, we're looking at the processes as well. If the law says this is how you're supposed to spend money, whether it is budgeted or not, there is no reason you should spend budgetary funds directly. It means that anybody can just do it. So it's either that's the problem, the Accountant General means that they just spend this money without without following due process or something. We will come to Attorney General later. But let me read this out to the Attorney General because it's correspondent, which brought about this morning. Some request for approval for a fair critical payment in respect of Federal Ministry of Justice from the recovered funds. That's the heading. It says request for approval to a fair critical payment in respect of Federal Ministry of Justice from the recovered, which means the Attorney General knows that this is coming from the recovered funds, which means that the Attorney General knows that he's making a request that is against the law. That's by correspondence reference 08MF/PICA/PRES/61 volume 135. The Minister of Finance indicates that the Solicitor General of the Federation and Permanent Secretary of the Federal Ministry of Justice is requesting for additional funding for the prosecution of cases. Additional funding for prosecution of cases. The Honorable Attorney General of the Federation and Ministry of Justice is requesting for additional funding for payment of accrued solicitors' fees. You see, what we're saying is you're asking for solicitors' fees and funding of cases from a recovered fund account.
No, don't worry.
I don't think it's proper. I don't think it's proper. I think that's what we're drawing attention to. There are other things there that security issues that I do not want to read out. And the question I would have asked you that I can't read out, especially when it comes to Mr. Attorney, don't distract him, please. The questions I want to ask in regards to the payment you received, this payment of 2 billion naira you received for prosecution of terrorist suspects. Was this supposed to come from that account, or should have been part of your budgetary spending?
Yes.
Is it that when you exhaust your budget, you ask these people, send me some money? Thank you.
Mr. Chairman, I think document I am talking of the letter dated 16th January 2017 is concerned, which was forwarded to me by the committee for consideration. 1. No reference was made in paragraph 1, which is the opening paragraph, to any correspondence emanating from the Attorney General. I think that should be clear. And then 2, the title of the letter is not re, which implies a previous correspondence. Until the originating correspondence is made available to me, honestly, I am not in a position to join issues over the title, much less of the body of the letter. There is nothing either in the title as indicating a previous correspondence from the Office of the Attorney General, neither is there anything in the opening paragraph making reference to a letter from the Office of the Attorney General. Mr. Chairman, I humbly request that if there is originating correspondence from our office, it should be made available to me to refresh my memory.
Thank you. Like I said, I'm drawing your attention to this because you're the chief law officer.
Yes.
And you know the law more than all of us.
Yes.
And so when we're doing, I think that's what we want to put on record.
Yes.
Thank you.
Yes, but even at that,
Mr. Chairman, as I stated earlier, I maintain my position. This is a singular document that is presented for my consideration, and no opportunity has been accorded to me to find out from the Minister of Finance, Budget and National Planning for the purpose of having a holistic assessment of the situation. I cannot jump to conclusion in terms of judgment on the basis of a document that is perhaps alleged to have emanated from a source without interrogating the source, Mr. Chairman.
We will interrogate the source. Two movable assets. Who keeps the inventory?
the inventory.
Yes.
Before now, the agencies of government that is responsible. For example, if on account of sting operation, DSS now perhaps maybe recovered certain assets, it remains in their custody. If on account of perhaps investigation, EFCC make recoveries of certain assets, the assets remain in its custody. And they were the exclusive custodian of knowledge and information associated with it. And the same thing with NDLEA, the same thing with customs and all other agencies of government. Whichever agency make recovery remains the custodian of the asset.
Mr. Chairman.
Yes.
No, please, Mr. Chairman, sir. As far as I am concerned, I'm Representative representing Nabelkota, sir. That's the question, sir. Your question is direct.
Okay.
So
within the
it means
context.
it's direct answer. There's no reason for if. Your question is direct. So a direct answer first, then any other thing can follow. Thank you, Mr. Chairman.
Recovered is responsible for the maintenance and keeping of the asset.
Okay, so since you established interministerial committees coordinating sales, isn't that the right thing?
Yes, the asset trace, the interstudy remains with the agencies that
the question is about inventory.
The inventory as to what has been what has been taken or has been recovered, and then from whom, and then the status as to whether it is entering or final forfeiture. The Federal Minister of Justice that has now created a database arising from the absence of coordination with a view to bring about the desired transparency, accountability, and coordination of the process. So it is a new innovation being brought into the process of the asset recovery.
Disparities in returns by different agencies. Let me give you an example. Vessels. The FCC says they hand over this number of vessels to your office. The Navy gives a different number, and you have a different number. The same items, different inventories, different people. Why do you think this is happening?
Why the inconsistency? And I think that is why the oversight functions are put in place. I would suggest perhaps that the National Assembly should exercise its oversight functions. I am not in all sincerity in a position to confirm the inconsistency or discrepancies associated with the number of assets.
You set out a list of assets, especially vessels that you sell. You have court case, I think you came about 138 vessels.
Yes.
Where did you get this list from? Is it not from the agencies?
From the agencies, yes.
Okay, so which means, I mean, if I get 10 naira from 3 different people, it will amount to 30 naira, won't it?
If you ask me a question,
no, I'm trying to just please.
Yes.
We're friends.
We are.
Thank you very much. If I receive 10 naira from 3 different people, how much will it amount to?
From how many people?
10 naira from 3 people.
30.
Good. So now, if at the end of the day you now find out that 10 naira from 2 different people amount to 24,000 naira, won't I be right to ask questions?
You are entitled to call for reconciliation.
Thank you. I think that's what I'm asking, because the contradictions, the questions we put to the EFCC where they show up, and then of course the Navy when we meet with them, because there are contradictions that we need to reconcile.
Well, if there are contradictions, I suggest that you first a resolution.
Thank you very much.
I will call on the PAMSEC to address that question. He is the chairman of the committee put in place, Interministerial Committee for Disposal.
I think there was a judgment from the Federal High Court, Lagos, striking that regulation. I don't know whether what you have done, because somehow I appreciate the testimony and then your effort to see that our laws are strengthened so that we can manage this recovered assets. But I don't know what you are doing with that position of the Federal High Court Lagos striking that regulation. I don't know whether you're aware of that. And what are you doing so that at least it will help you continue to manage these assets that are recovered?
Which states that the executive functions of the Federal Republic of Nigeria shall be performed by the President or the Vice President or ministers or all the ministers or other public officers. And upon that, and also by virtue of the asset tracing, recovery and management regulation of 2019, having laid the foundation, let me just quickly brief you on what we have done.
Now, I think you quoted the Constitution.
Yes. Yeah.
And I think you should answer that other question first.
No, I'll answer that one.
I think you should finish that.
No, that question is, can I first of all answer that question?
Yes.
That, the judgment, which is the Honorable Rep has referred to, is not directly, with due respect, it was a judgment given against the EFCC, not to the Honorable Attorney General. Attorney General was not a party to that judgment.
What was the content of that judgment?
No, I might not correctly remember it, but I know that Attorney General is not or was not, whichever way, because I learned that the EFCC is handling that on their own. But if Attorney General is not a part to a matter, how is it now relevant with that, with due respect? So that issue, sir.
Mr. Pierce, I'm not a lawyer, but then if there's a judgment, are you not required to take judicial notice of the judgment?
Sir?
I said, if there was a judgment
that judgment,
the reason I'm raising this is that you said the judgment was against the EFCC.
That is exactly what I'm saying.
EFCC is part of the interministerial committee.
No, the EFCC, I can't readily grasp the judgment, but what I read in that judgment, in that matter, is that the EFCC went to court and they raised that issue, and court made an arbiter on that issue. But as it relates to the functions of the of what the president has already submitted, I don't think it has any relevance.
PS, with due respect, let me help you.
Can you speak?
I'm sure you know the title of the judgment, but just keep the title aside. What we are saying, that regulation was based on EFCC law. The regulation that was formulated was based.
No,
hold on, sir.
That is not the judgment, sir.
Hold on, sir. I want you to educate me. I'm not interrogating you. I want you to educate me so that the job the House gave us to make a good assessment on the status of all recovered movable and immovable assets will help us to come up with a beautiful report that will table before the House that will help the Nigerian people. I just want you to educate me. There was a judgment on a regulation made by the Attorney General, the Chief Law Officer of... We're not interrogating the Attorney General, no. But what we are saying, there was a judgment on this recovery, tracing, recovery management regulation, which was attached to, which is part and parcel of EFCC law. That's the point I'm making. What are you doing to address it so that it will help us in moving forward, adopt effective recovery and management of these assets? Since you have some impediments, there is a judgment. What are we doing?
Let me answer. Sorry, Honorable Sada. First, by the Attorney General in pursuance of the statutory functions vested in him arising from the EFCC Act. It is only logical in the circumstances that when the authenticity, validity, and efficacy of a regulation is an issue, a regulation passed by the Attorney General, it is only logical that the Attorney General should be made a party, because that will afford the Attorney General an opportunity to now join issues where an instrument that emanated from him is an issue. But over and above all, I think what needs to be emphasized as far as the judgment of a court is concerned are two fundamental and key things. One, whether the pronouncement is reason for the decision or is an obiter, a passing remark. And that is where being a lawyer will make a difference. A judgment, a pronouncement by a judge that is a passing remark cannot constitute an issue, a binding issue for that matter. And a pronouncement that is the reason for the decision can only have been possible where the Attorney General in the circumstances was made a party. And I am happy to state that the Attorney General has not been privy to any case where the regulation in its own right is presented for determination of the court. And to my mind, the likely position is that there was a passing and not a binding remark. And if it was indeed a passing remark, it does not hold water for the purpose of establishing a position, a legal issue. But at any rate, when a judgment is an issue, the best way you can do justice to it is to read it over. Unfortunately, I am not in a position to come up with a precise position related to such document because I have not indeed gone through it. Thank you.
Let me just quickly give an general what we are doing presently.
Let's not develop too much. I just want to understand the process, how you acquire items that you're into auction. I think let's just deal with that.
What we have done is to, since the Attorney General had already stated that all the MGs, ICPs,
submit to you.
EFCs,
Do you keep inventory of them?
Submitted to the committee one, and they submitted the list of the forfeited items. There are three types. There are some that are under interim forfeiture. There are some that are under final forfeiture. There are some that are still under investigation and pending in court. So those ones that are under forfeit, that has already finally forfeited, what we have done is presently we have gone out to, number one, we place advertisement in the paper for valuers, just like the Attorney General has already said, and we have already received valuers, estate valuers to value all these assets. That's number one. Then number two is that the assets have now been, or they are now being tagged so as to identify those ones. After that one, if you remember, about 2 weeks ago, we put in advertisement for auctioneers, so that we are calling in the auctioneers so that after the valuation of this thing, which is also in conjunction with the Federal Ministry of Housing, Federal Ministry of Housing, then we now go into the auction. Thank you very much.
By way of further elaboration, Mr. Chairman, the interministerial committee put in place have indeed first obtained the necessary court orders. As you know, constitutionally, you cannot dispose of an asset without the benefit of a court order. So those court orders, in some cases interim and some cases final, were obtained. With those court orders, we proceeded to the next step of valuation of the asset to ascertain the actual price I should go for. And that has been done by the auctioneers and in the working with the Federal Ministry of Finance, Department of Valuation, Federal Ministry of Works and Housing, which has a department that is responsible for valuation of assets associated with the federal government. So the next process is publication of the assets generally that are under final forfeiture, available and ripe for disposal, and entertainment of the general public to bid for such assets. And then on the basis of such bidding, the final decision of disposal can now be taken. So perhaps maybe by way of further elaboration, that I think is equally helpful.
Okay, so the question now is, have you carried out any sale before now? Any auction?
Any auction?
Have you carried out any auction of any asset?
Chairman will answer.
Was before the inauguration of this committee. Let me just quickly state from example, the Navy finds out that there's most of these vessels, sometimes they create major environmental problem into our heights. They write to us requesting that these vessels have some problems and there's a need for urgent disposal. And while we're doing that one, so these are the ones that we have done before the inauguration of this committee.
Okay, so what was the term for that auction, the one pre-inauguration? What was the term? What was your agreement with the auctioneer? The reason I'm asking is, how do you pay the auctioneer?
How do you get the auctioneer?
How do you pay the auctioneer? I mean, if someone does a job for you, you're going to pay him. How do you pay him?
It was advertised.
How do you pay him?
Pay,
yes. You have to pay the auctioneer, or do they get a percentage of sales? That's what I want to know.
Well, from the Navy, establishing that we constituting obstruction in the national waterways. Obstruction in the national waterways, among others, on account of the peculiar circumstances and situation, we wrote to the President, intimating the President on the need arising from the request of these agencies to take immediate steps, and that was before the 2019 regulation. An approval was given. Arising from that approval, these vessels were assessed in terms of, in value sense, by the Federal Ministry of Works and Housing and the Office of the Attorney General on the basis of the law allowing the office to conduct the sales, took a decision to dispose those assets, and the proceeds were eventually deposited into the asset recovery and management account. And then thereafter, because the office arising from the law equally was empowered to engage associated services, but those services cannot be paid by the office, can only be paid by the Federal Ministry of Finance. So the associated documents establishing engagement are forwarded to Federal Ministry of Finance for processing and payment.
I'm sure you don't know from which account the payment is made.
Certainly.
Okay, that's what I started, but
maybe I will give you a general answer as well. International. The Office of the Attorney General had course to engage lawyers, local and international, to engage in the recovery exercise, and they do that for a fee.
Yeah, right.
We are taking notes, and I will kindly ask you to advise the minister to be very specific. What I have witnessed so far is stories, and we're writing notes because some of your answers are, Mr. Attorney General, could be evasive, if I'm allowed to say that. But we know you are rendering account as much as you know, and we appreciate that. But we must be able to put something down. So, Mr. Chairman, we want specific answers, because by the time we have all these stories, we can't write anything. We need to have a reference point. Thank you very much.
Seeking confirmation from the central bank, and such confirmations are received. I write to the central bank in respect of each claimed lodgement made for confirmation before processing and taking further necessary actions. And the CBN kept confirming the receipt. And then in respect of each and every one that has not been confirmation, we can certainly not take any action over it.
Thank you. I'm just going to draw attention to that. First, I'm in receipt of your letter, your demand, written 23rd May 2019. And I think before that, you had written a letter to the CBN asking for confirmation of the payment of 153 million naira, which they wrote you a letter back on 12th April 2019, specifying that the amount was received on 30th of March. We have looked at the statement of account submitted by the CBN. Statement of account as well. Everything. And the amount of 153 million, which they said they've received, is not in the statement of account. We can show it to you, please.
Without going through the documents provided by the chairman, let me state that my duty in the corporate sense is to ensure that value is, the amount is lodged with the central bank for confirmation. And I'm not in a position, because I do not operate accounts with the central bank. That is the more reason why I had to have recourse to them where a claim of lodgement is made. And
I think I explained to you
and
that
if
we're giving you information as well. We're dealing with management of public funds, public assets. We want this thing well managed, you want it well managed, which means we're drawing your attention to this now to see if there are other ways in which you can actually monitor that this is actually received.
I have no any other way in life to confirm lodgement with the central bank other than a correspondence from the central bank. So if there seems to be any perhaps infraction or perhaps associated inadequacies associated with such information, I think the central bank is in the best position to answer that question.
No problem. We have invited the governor of CBN because we need to understand how 153 million naira of public fund got missing in transit.
Please.
We've got to find out if it's still in the pipeline, and we'll look for the pipeline.
On that infraction, because I'm not in a position without your prompting arising from your constitutional role to now perhaps maybe identify this inadequacy or lacuna associated with it.
I think that's one of the things that was coming to, that we will have opportunity to have further interaction with outside this public hearing.
Okay.
Because there are a lot of things we need to draw your attention to.
Yes.
We mentioned to you a lot of things. I mean, we've already done almost half a day. We have
Yes.
about 30 questions. We're taking just about half of that.
Yes.
And we want to actually be able to take the accountant general, because there's a correlation between the question we're asking you and its office, and then of CBN as well. So we want to be able to take their side, so that when we have further questions, we will invite you and talk with you again.
Okay, thank you.
So we thank you for your cooperation. We
Thank
thank
you.
you for, understanding that it's a public duty to all.
Yeah.
Wonderful. Mr. Accountant General.
Thank you.
Thank you.